A 28-year-old Illinois woman is accused of sending nude pics to a teenager. And even worse, she was working as a juvenile court counselor at the time of the incident. Bayleigh Hoyt is now facing felony charges as police say she sent explicit photos to a 17-year-old boy who was in custody. The details of this case could shock you, but let's start at the beginning. It dates back to 2019 when Hoyt started working as a juvenile counselor at the Robert Depke Juvenile Complex Center in Vernon Hills, Illinois. The facility works to help rehabilitate troubled teens. Now, authorities say Hoyt met the 17-year-old boy, the survivor in this case, while he was in custody at this center. He was later released, and after that, that's when the two started communicating outside of the facility. But what started as friendly messages quickly turned into something much more disturbing. Hoyt apparently engaged in lewd text messages with the teen and sent him naked photos of herself. Investigators even say Hoyt encouraged the boy to delete these messages and photos to avoid getting caught. In January of 2023, Hoyt resigned from her job before law enforcement learned of this inappropriate behavior. But it didn't take long for police to connect the dots. The Lake County Sheriff's Office launched an investigation and soon discovered the full extent of what allegedly happened. According to court records, Hoyt was charged with official misconduct, that's a Class 3 felony, as well as distributing harmful material to a minor, that's a Class 4 felony. Authorities issued a warrant for her arrest, and she was taken into custody while she was working at her new job, which is even more shocking. According to her LinkedIn, she had just started working as a paraprofessional at North Shore School District, just days before her arrest. Now, a spokesperson confirmed Hoyt was immediately placed on leave and is no longer allowed on school property. Yet another disturbing case on the docket today. We're breaking it down now with criminal defense attorney and former prosecutor Kathleen Bogenschutz. Kathleen, thank you so much for coming on with us today.
Thank you for having me.
Okay, right from the start, this is the question that goes through my mind all the time with these cases. We have an adult who's sending these explicit photos, so there is evidence. We have the photos. Why send these photos that are going to be incriminating?
Why does anybody do anything? It is ridiculous the kinds of idiocy that some people get up to. Frankly, when I was a prosecutor and I would see somebody do something literally this stupid, I would oftentimes say to a jury, "You're right, this person isn't smart. We don't catch the smart ones." I mean, because it just defies all explanation to create that kind of a paper trail. And you have to imagine that there's, the thrill of getting caught, the thrill of knowing that it's improper. That kind of heightens it more than it would for a normal romantic relationship.
You're right. I think the fact that they were communicating and it's not allowed, maybe that was a reason that she wanted to participate or do it. Something that also stood out to me too about all of this is she was messaging the 17-year-old and encouraged him to actually delete the pics, get rid of them, get rid of our conversation. That to me is consciousness of guilt. What do you make of it?
It's consciousness of guilt, and I try not to make it, part of what I do daily to help people get away with crimes or to help them commit them better. But nothing's really deleted on a cell phone. There's usually a way to get your hands on it again. And I don't know how many times you have to tell the general public this, that it's not going to go away. But we do see this quite a bit. For example, in my area in Tallahassee, we have FCI, which is a women's federal facility. And I cannot tell you how many times we have seen the guards with the inmates. But what makes this unusual here is that first of all, it's a counselor, right? But the second thing is that it's in a juvenile detention facility. So that's I think what kind of piques the interest here.
Let's talk about that because we've had you on our show before. We've talked to many other people about these similar crimes where an adult woman is sexually assaulting a child, but oftentimes it's a teacher. It's not someone I've yet to see, a counselor at a juvenile detention center, basically what we call juvie. That really stands out to me. How do you think that relationship would have started? Would there have been grooming at the juvenile detention center?
I don't know. I know how ours are run in Florida. I know this is an Illinois case, so I can't speak to how Illinois runs their juvenile detention facilities. It's going to be state specific. But usually, what happens is juveniles are not shackled. If they're detained in Florida, they're only detained for a short period before trial. And occasionally, they can be sent to facilities that are like leveled up programs for longer term periods of time. And it wasn't clear to me as to whether this was a temporary detention pre being adjudicated delinquent, or if this was maybe a treatment facility, because they will have counselors in both of those places. The Department of Juvenile Justice in any state, when they take custody of a child, and of course 17 is still a child, they're responsible for health, medical, and schooling too. So a lot of times these kids that are in custody, they've got other issues, so they're responsible for making sure a counselor can get in to see them. I don't know if in this state counselor is maybe a similar to a probation officer, or if this is a true like PhD social worker type of counselor. Either way, it's clearly highly inappropriate and illegal.
Let's talk about that counselor side of things. I know you said we don't know exactly what type of counselor she was because honestly, a lot of facts about this case have not been made public. I think maybe part of it is that we have a 17-year-old who is obviously under the age of 18. So let's just say, for instance, that she is the traditional type of counselor that we think of, a mental health counselor to some degree. Is that a major abuse of power? Because this young student, this child, would be coming to her and talking to her about very intimate things, and she's then creating a relationship with him outside. I mean, is that again an abuse of power?
Yeah, and in my state, we also have an additional, like a way to up this kind of a charge. So it's against the law because of his age, sure, but it's also against the law because this person is in a custodial status of the child. So we have familiar custodial status, so somebody who is in charge of the child, a teacher, a coach, a tutor, sometimes even an aunt or an uncle. I hate to say it. So, but it does bring me back to the one of the things that I learned when I was prosecuting sex crimes, and I did that pretty exclusively for about 8 years, or exclusively for 5 years, and then another 3 after that. What do you need? And I'll take your viewers down the rabbit hole. What do you need if you were the kind of person that wanted to commit this kind of an offense? You would need privacy and access. These are not the kind of crimes that occur on the 50-yard line during the Super Bowl. They occur in private, and they occur in places where they can be hidden, and you need access to the person that is the victim. So in this scenario with a counselor, let's assume it's an actual counselor, like social worker, clinical, you're not only going to have access because you're going into DJJ for this meeting, but you're going to have privacy because the child is still entitled to privacy in their communications with this counselor. So you have both of those right there if you were the kind of person who wanted to do this. So, I mean, it's almost, and as a parent, it horrifies me. But when you're thinking about maybe having a discussion with your kids about this, and I'll say this as a PSA, if anyone is trying to get you to keep a secret from mom or dad or to keep a secret, that's a red flag that you need to come to us directly. So it is the secrecy, it is the privacy. These things do not happen out in the open.
Hey, so I'm going to take a guess and say a lot of you who watch our videos might be business owners, maybe even starting some sort of side hustle. That's why I have to talk to you about our awesome sponsor, Odoo. It's a free all-in-one business management software that provides you with a range of apps, all that help with the day-to-day of owning a business. One of my personal favorite Odoo apps is their project apps. There are even multiple views in the project app. So there's the Kanban view that organizes tasks by stage, or there's the Gantt view. That one gives you a timeline of your tasks. Seriously, it makes things so simple and easy to organize. Also in the Projects app, you can directly bill customers according to time spent on tasks, and that is just a big time saver. So right now you can click our link odoo.com/lcnews22 and try Odoo and their projects app for free today. Yeah, it's really a recipe for disaster because if you have other people who are there, it seems that these predators wouldn't commit these acts. And I wanted to talk to you specifically because you have that history, as you mentioned, as a sex crimes prosecutor. Her charges after all of this are official misconduct and distributing harmful material. Do you think that those are appropriate charges?
It's really going to depend on what comes out of this. A lot of times when someone is a victim of one of these offenses, particularly male victims, in my experience, what happened comes out piecemeal. Um, that if you're a male and you are a victim of this underage, that that you should like it, or you think it's cool or a big deal. And maybe in 10 years you're going to look back on it and realize exactly what happened. But it tends to come out piecemeal, and boys tend to not be as forthcoming as girls when these things happen. So it is entirely possible that there was a what we call hands-on crime in this, as opposed to just the texting and the pictures. Hands-on being that there was some sort of physical victimization as opposed to the texting, and that we may not find out about it until later. And the other possibility is that there wasn't, but there was some kind of solicitation. So when they dump these cell phones, like for example, this is my iPhone, I forget what year, but it's relatively recent. It has about a terabyte of storage. It takes this is a computer in your pocket. If you try to delete things from it, there's usually ways to get it back. There's pictures, there's latitude and longitude data on it, there's dates and times, and you can pull those out of the pictures. So I get the feeling there's going to be a full forensic on every single device that this woman had in her home, as well as every single device that the child had. And sometimes that does take some time.
You brought up something so important, and I wanted to highlight it too. It's kind of a through line through a lot of these stories that we cover, in that there's this stereotype that young boys, if they're having these intimate relations with their teachers, they should be excited. They're the chosen one, they're lucky. And I'm really happy that you brought it up. Boys can be victims. Men can be victims. And so sometimes it makes it more tough for them to come forward. But I'm glad that you brought that up because it is serious no matter the gender. But kind of going off all of that, let's say this is taken to a jury trial. This boy would be the key witness. How would that testimony look like if he doesn't necessarily want to be super cooperative?
And then you also have something in this case that you have in some inmate cases. And for example, I tried a federal case where an employee of the Federal Corrections Institute was having relations with inmates. The mere fact of them being inmates, and the mere fact of him being in the detention center, you've got that built-in credibility buster right there. That like, oh, this is a juvenile delinquent. Oh, he's been in trouble before. Usually, if kids are being held in the detention center, there's some kind of a history or it's a more serious charge. There's like a presumption for the kids to go home. And I'm obviously glossing over quite a bit here. I'm just telling you how it works in my state. So you probably do have either a serious charge or a fairly, decent history of a couple of different arrests with this child that you can look back on and say, I put that up in front of the jury and say, you want to trust this kid or you want to trust my client with the PhD or the social work degree? So, it's built in to not believe somebody with that kind of a history. That being said, the electronic trail is pretty damning. And it's entirely possible that they decide, even if there was some kind of hands-on offense here, that maybe we just go with the electronic trail because, I've got this victim and he's not particularly, he's not as lily white as I would prefer to have him. But, and again, go back to things that I would say to juries in closing. People lie. Phones don't lie. Computers don't lie. Dates don't lie. Times don't lie. People lie. and you bring it back to that, and maybe you just go on those offenses with the transmission of uh, the statements and the pictures to go after them and make it a real clean case right there.
You're right. I mean, that's how we opened this interview, talking about how there's literal evidence. We have the messages and the photos. We have it right there. And again, you brought up going through her phone history, likely his too. There's a treasure trove of information that could be there, which leads into the next question I have. I mean, if she pleads not guilty, it could go to jury trial, but it seems like the prosecution may have a pretty strong case with these images. Do you think this would be more of a jury trial situation or maybe striking a plea deal?
Well, a lot of times, and I do criminal defense now, and having specialized in sex crimes for so long as a prosecutor, I do tend to get quite a few sex crimes cases. A lot of times, when the state makes you an offer as the defense attorney on a sex crimes case, the real question is, do you want my guy or girl? Do you want them designated? Do you want them to be a sex offender for the rest of their lives? Do you want their picture on the internet with the scarlet letter on them? And a lot of times it really doesn't matter what else goes along with that, whether it's just probation and no incarcerative sentence. But a lot of times we will try cases over that point alone, because it's a pretty onerous thing to be designated as a sex offender. So while I might think, yeah, we've got quite a bit of evidence here. Number one, I don't know if these charges would designate you in Illinois. But number two, let me point out that even if there is this sweetheart plea deal, a lot of times we try these cases over just the designation, just the scarlet letter of A or the scarlet S for sex offender.
A lot happening in this case that we're definitely going to want to follow, see where it goes, and a really tricky topic to talk about too. So Kathleen, thank you for coming on and shedding some light on it for us.
Thanks for having me, and happy holidays, everybody.
For now, Hoyt remains behind bars in the Lake County Jail, and according to court filings, she's due back in court on December 18th for a status hearing. Reporting for Law&Crime, I'm Sierra Gillespie.